Hi there, I'm James Apogee, and this is Coffee and a Case Note. Necromancy. When can we bring a piece of litigation back from the dead, and when can we keep it in the grave? Lawyers talk about concepts like res judicata, or cause of action estoppel, issue estoppel, Anshun estoppel. What we're going to have a chat today about, guys, is abuse of the court's process. What is abuse of process? Abuse of process is if a mechanism of the court or a otherwise legal operation of the court acts in a way that is unfairly oppressive of one party, or acts in a way that is likely to bring the administration of justice, particularly the court, into disrepute. So can I have those finality of litigation, when does it end, arguments, and the abusive process, those two limbs, unfairly oppressive, legal system disrepute, in your head as we jump to a set of facts today. Right. We've got, for want of a better word, an advisor party that is a large, sophisticated financial entity, and we've got, for want of a better, clumsy phrase, a trustee and beneficiary set of parties, where essentially our advisor party gives advice to our trustee, who acts upon that advice, hopefully for the benefit of these various related entities here. Now, the particular advice we're concerned with is our advisor saying, hey guys, what you need to do is to buy some bonds and to really double down on the Kazakhstan banking system. Now, I know very little about the Kazakhstan banking system, but in short, the investment doesn't go precisely as all the parties had planned. Our advisor calls upon some collateral from the trustee beneficiary parties, and they essentially say, no. The advisor says, that's fine, commences proceedings in Singapore. Understood? So we're in Singapore. What happens over here is that our trustee and beneficiary parties commence proceedings in the New South Wales Supreme Court. And what they are looking to do is sue our advisor party over here on the basis that they made these bond investments without the authority to do so, that they made some misrepresentations about the Kazakhstani banking bond market and other relevant negligent acts in relation to the provision of their advice. Does that make sense? So we're in Singapore and we're in New South Wales. In Singapore, our advisors seek an anti-suit injunction. Essentially, they make an interlocutory application. They get up. There is an appeal made by our beneficiaries that fails. There's another appeal that they don't appear at, and there is a degree of success over here at an interlocutory stage for our advisors, but the Singapore proceedings remain on foot. Now, over here in New South Wales, what happens is that our trustee beneficiary parties are granted leave to amend their claim. So they've got an original document that says this is all we claim, A, B, C, D, E, F, G, and this is who we are, Party 1, Party 2, Party 3, Party 4. And they are given leave to amend that originating process. And they make a number of amendments, but relevantly for us, they remove two parties. They remove the corporate trustee out of the claim, so they're no longer in the New South Wales proceedings. And they remove the natural person, the real guy, who was controlling that trustee out of the proceedings. So now, the New South Wales Supreme Court fight is going on without these two, and the Singaporean fight marches on. Our advisors call upon their collateral and essentially get up in Singapore. So then we turn our attention to New South Wales. What happens there? To keep it real short as best I can, our remaining beneficiary parties, remembering that we've extracted these two over here, lose. They go down. Now we turn our attention to today. Remember we extracted our two parties over here? Remember these two? What they do is they get back in the game and they commence federal court proceedings in Australia against our advisor based on very, very similar facts. These come before the federal court at first instance, and the first instance judge says, no, abusive process, they go down. Then we go to the full federal court, so that's an appeal of that first instance judgment, And essentially our first instance judge gets rolled and says, yeah, that's fine. The first instance judge didn't get a chance to dive into all the knotty little issues in this claim, and so it was not an abusive process. And so our two little extracted parties are free to make the claim. But, and now we finally get to what we're discussing today, it comes before the High Court. There's an appeal there. Our advisors are saying, now come on, surely we can keep this body in the grave. Surely we're done with this litigation now. And to give away the ending, the High Court says, yeah, that's right. Because to allow our two extracted parties to come back from the dead, to put it very loosely, would be an abusive process for two reasons. Firstly, it would be unfairly oppressive to our advisor party, who, despite the fact that they're large and sophisticated and whatever else, are entitled to arrange their affairs as if the body remains dead and buried. And then secondly, it's an abusive process with the potential to bring the justice system into disrepute, because someone looking on might say, is this really what the resources of the federal court are being applied to rehearing something that's been heard in Singapore, New South Wales, and there have been a couple of appeals of? So, I hope that gives you a bit of an insight into abusive process. We lawyers sometimes think about, how do we keep proceedings final? How do we keep the body in the grave? And we think about things like res judicata, or cause of action, estoppel, which sort of means that point's already been decided and you are estopped, or legally prevented from pursuing it. We sometimes think about issue estoppel, which means that the parties in the litigation are sort of prevented from departing from a finding the court made in other litigation, potentially in a different jurisdiction. It's sort of fiddly, and we can talk about it another time. An Anshun estoppel, where, to keep it really broad, essentially the position is you should have brought this claim as part of your previous claim. So you can't bring your second one because you should have done it the first time. So there's some of our finality of litigation limbs, and what I hope we've done today is bring to your attention the potential for abusive process to form one of those limbs as well. It's been a long journey, it's been a little bit of a wet journey for me, but I hope there's been some value for you, and I will look forward to joining you again soon on a more stable table for another coffee and another case note. Cheers.